potential pill mill issue. And so what we did in the substitute is to, what council did, and with the committee's approval, was to set up a protocol, for lack of a better term, of an individual can't get the card unless they go and have a recommendation from their doctor, and that we set up rules and regulations for the medical board to set up processes, mandates that they'll have to go ahead and follow in order to make sure that we don't have just a random doctor making a recommendation and they go ahead and get a card, because that's just not enough quality control there, not enough process control. And I appreciate that, Representative Peake. That was one of the main concerns we heard about the replication of that problem. And if you notice in that section, it goes to there are certain mandates within that the board shall establish procedures and promulgate rules to assist physicians in providing required uniform information. That's on 8889, related to certification, any other matter related to issuance. In promulgating such rules and regs, they'll require the doctor-patient relationship when certifying, required to be treating the patient for the specific condition. So we're setting up, it's not just some random doctor and a random patient. There's got to be that relationship there. And I think that what it does is it vests proper control and authority ultimately with those individuals who are in the best position to make a recommendation, and that's a physician. And that's really a treating physician, as opposed to us, for lack of a better term. And then what that'll really do is it'll vest that authority with those medical professionals, and then they'll go and then what it does is it positions those particular patients for potential treatment, and we go on from there. Oh, let me turn that off. I'm sorry, go ahead.
I'm fully supportive of that. Keeping the doctor-patient relationship at the core of kind of what we're doing, I think, is an important thing to do.
The other major aspect, of course, was the treating conditions. I think the author made a point himself previously that, a lot of the conditions that were there, if not all of them, were based on, anecdotal evidence, for lack of a better term. What we tried to do is to formulate a list that was neurologically centered and focused. At the end of the day, it doesn't preclude the possibility of an expansion in the future. I would also say that the conditions that are there, politics is the art of the possible. I think this abridged list of conditions puts the bill in the best position to earn support on the other side of the Capitol and the other body, and also to get a signature.
That's correct. Yes,
and that's what this exercise is about. Is we don't want to go through this and then earn a non-approval of the bill. So, of course, this is the first stop. We'll be on the floor, then we'll be in the other body. We don't know what the Senate is going to do. This bill will inevitably end up in a conference committee, and it may look very different than what we do here today, regardless of what amendments may be adopted.
Right.
But we march forward.
That's right.
Anyway.
The only thing I would add to that, Chairman Gold, is just those 8 conditions that are now in this bill are consistent with what has been done in other states as well too. We've tried to say, okay, here's kind of the benchmark of what's included in those states, and that's what we've done. Kind of got to that list from that direction.
Thank you. Finally, the THC level was reduced from 5% to 3%. Part of that was to err. Of course, 3% is significantly higher than what almost passed on the last year, correct?
Last year, the final number was 0.8%. That's correct.
So 3% signifies a significant increase in the maximum level of THC, potentially, that a doctor may recommend. They may recommend 3, they may recommend 2, 2.5, 1, 0.5, depending on the patient, adult, child, condition, and that's going to be a highly individual analysis. 3% puts us at near, if not at the top, of what other states in the country, what 2 other states, I believe, Alabama and Iowa,
that's correct,
have allowed.
That's correct.
I take a little more comfort in the fact that if we are setting up a foundation whereby it's ultimately a physician that's going to be the gatekeeper on this thing, as per the rules and regs promulgated by the board, which must occur, the recommendation and the documentation that goes along with that in order to get the car from the DPH. If we're ultimately setting up the physician as the gatekeeper on that, and I think that's appropriate, then that begs the question of, well, if a doctor's, why have a limitation?
Yeah.
And that's a fair question.
Right.
The substitute that I have here is I don't know if I'd call it a starting point, but I think it's a common sense foundational middle ground that could potentially be built on or not, depending on what the will of the committee is going forward in the next few minutes. But I felt it important to have a reasonable starting place that the committee could take a look at and feel good about, subject to the amendment process, which will begin in a minute.
Okay.
So that if you had any reaction to that, but I wanted to just openly acknowledge that, because if you do have the doctor the fallback position that I cling to is the fact that the doctor is going to really be the gatekeeper on this thing. Right. I think that gives nearly universal comfort to those who had concerns about the bill, but that does inevitably beg the question about, well, if a doctor is going to be in control, why would you have limitations on it?
Right.
It's a fair question,
right.
And that's why we have the committee process to work that out.
Yeah, and I'll just add a couple comments on that,
yep.
Mr. Chairman. We came up with the original 5% in the bill that was brought before this committee a couple of weeks ago, basically because we have 17 examples of families that have moved to another state using a low THC product. In fact, one of those families is here today. Miranda Sievert, who I think is sitting behind me. Miranda has moved with her mom, Michelle. I think she's back there somewhere. Yeah. And Dad Vince to Colorado. Vince and the boys have stayed here in Georgia while Michelle and Miranda have been out. And she's probably the oldest of the 17 families that moved out there. And so she's not a small child. She's an adult. And she, Vince, you can help me, is using 4.8% THC.
It varies between 4 and 5%.
Yeah. And so it's clear that there are families who we're trying to bring back home who are using up to that 5%. We also have had a couple other examples of a young woman who's here today, too, who is from my hometown. Her name is Katie Crosby, 26-year-old adult. I think Katie is here, I think over there, and who's actually been out to Colorado and has used a product that is 5% THC with her mom and dad. Going out there with her, did not see any psychoactive effect from that and saw some real benefit. So that was the logic behind going to the 5% in the original version, not just some arbitrary number, but you're right. The question is, should there be a limit at all? Okay. If in an abundance of caution we are going to put a limit, why not put a limit if we're going to have these conditions that provides benefit, real benefit for the citizens that we're trying to help? And the only thing else I would add is, you're right, it is on the high, 3% is on the high level of what's been done in other states. Virginia just passed a law this past week, passed both chambers and heading to their governor's desk that is a 5% THC maximum. So we wouldn't be out there alone, even at a 5% level. So,
understood. And just so it's clear, I'm sure you've seen the amendment pack. We have at least 5. I've counted 5 printed amendments that we have. One of them does raise the percentage from 3 to 5. So we're leaving that to the will of the committee, and we'll find that out in just a moment.
The only thing I would say that, Mr. Chairman, is I would be in support of that amendment. I know there was also an amendment expanding the list of diagnoses. I probably would not be in support of that amendment at this time, because knowing what, as you stated so better than I could, the delicate process we go through here of making sure we have a bill that can get this governor's signature and pass the other chamber, I think we would be better suited by having a limited number of diagnoses that is in this bill.
All right. I appreciate your hard work. I think what we need to do for purposes of time is get to a motion, and then we'll have members who are sponsoring amendments to go ahead and explain their amendments. And we'll take the amendments, members, one by one, as opposed to in a package. Let me, and with that, I'll take it back for just a moment and then ask what is the will of the committee. The chair will entertain a motion. Sure. I'm going to recognize Chairman Cooper for a comment first.
Mr. Chairman, interrupting you, Pete.
I'm sorry. Is it? Yeah, go ahead.
Maybe, I don't think there's an amendment to this, but if in the rare cases, and we're turning the meetings to the discretions of the physicians, maybe as we go forth, what we could do is leave it at 3, since that makes a whole lot more people comfortable, but ask the physician to be able to petition the board in a extenuating circumstances, like you pointed out for these 2 people here, that they could be granted the right to go up to 5%.
Let me ask if we could. I appreciate the comment. As we go amendment to amendment, we'll have discussion on a per amendment basis, and we'll go at.
I mean, does it have to be written out?
I think 2351.
Like that? Oh, okay, sorry.
No, it's okay. I just wanted to make sure I wasn't
Okay. Thanks.
saying something inaccurate. Right. Okay. All right. Let me go ahead and we'll take a motion, and then we'll get to it. Is there a motion? Mr. Gravely. Mr. Gravely moves due pass of HB 1 LC 296421S. Is there a second? Second by Ms. Randall. Are there any amendments? Ms. Dickerson.
I'd like to amend HB was it AM292351.
You have a packet, members, of 4 amendments, and these are all from you, Ms. Dickerson. Is that correct?
I know they're not all from me.
Oh, okay. All right. Thank you for the clarification. But the first one there is AM 292351 by Ms. Dickerson. Ms. Dickerson will explain her amendment.
I'm just replacing the 3 to 5.
Questions for the author of the amendment AM 292351?
Mr. Chairman, I'll just again reiterate I'm in support of this amendment.
All right. Questions for the author of the amendment? Seeing none, all in favor of the gentlelady's all in favor of the gentlelady's amendment signify by saying aye.
Aye.
Opposed?
No.
In the opinion of the chair, the ayes have it. Is there a request for a hand vote? Hearing none, the amendment is adopted. Ms. Dickerson, was that your only amendment, or did you have the second one, 2352?
AM 2352.
Okay,
yes.
I'll ask Ms. Dickerson to explain her second amendment, AM 292352.
That is replacing lines 71 through 72. I wanted to add more of the diagnoses into this bill.
And which of the diagnoses are additional to what's in the substitute?
Well, I think the fibromyalgia is already in the bill, but the Parkinson's, glaucoma, AID, Alzheimer's, the muscle spasticity, post-traumatic autism, sickle cell, Tourette's, and terminal illnesses that produce one or more of the following: severe or chronic pain, nausea, or severe vomiting.
Mr. Chairman, fibromyalgia and Parkinson's disease are both already included in the original
right.
part of the bill.
So this adds.
Line 4 through 13 of the amendment.
4 through 13?
4 through 13
Yes.
would be new, additional from what the substitute is offering. Questions for the author of the amendment 2352?
Again, Mr. Chairman, for what
Hold
I've
on one
stated-
second. Ms. Cooper.
Okay, to the author, have you talked with the ophthalmologist? I know that they are not in favor of glaucoma. We have had a medical marijuana bill on our books since 1982, I think, and glaucoma was on that bill, along with cancer, terminal, basically the nausea and vomiting. There's now medication for that, but also in the glaucoma, what they found was that it did lower the pressure, but that it also raises the blood pressure. And since most people with glaucoma are elderly, having their blood pressure raised is not a good idea, and I know that the ophthalmologists were against having that included.
Right.
I haven't seen the list early enough to see about the other ones, but I know that was a problem.
Yeah, Mr. Chairman, I'm more glad to comment on that. I have chatted with the ophthalmologist, and they had no issue with including or including that. There was really not a dog in the fight. There was just a. In fact, yes. The point was that they, while it was in existing law now, if it was to be removed, they would not have any problem with it at all.
Okay,
So
I
yeah.
heard another thing. They feel like they're going to be inundated with people not medically.
No, I'm agreeing with you. I mean, the indication was from them that there wasn't any need to continue to keep glaucoma as a qualifying condition. There is also indication that in the past that it was only effective when it was smoked. We're not allowing that in any form or fashion in this particular bill, so I'm not sure it would be any merit to including it as well, too. Mr. Chairman, I'll again just reiterate, while I'm supportive of including as many conditions as possible, I think the list that we have is the most expeditious one that could move forward on a going forward basis. I would also, just a moment, express a little bit of frustration of the different state organizations that represent these particular groups who have not reached forward to say, hey, include us in your diagnosis. If these folks that represent these organizations need to chat with their state organizations and ask them if they want to be included in this piece of legislation, they ought to fight for it.
Point well taken. Any other questions for the author of the 2.3 Amendment 292352? Mr. Coomer.
Mr. Chairman. Thank you, Mr. Chairman. I just want to reiterate my agreement with the author's position and the concern really that what we'd like to do is see legislation that can get through this committee, through the House of Representatives, potentially through the Senate if they do their job correctly, and then have it go to the governor's desk for a signature. And I think we can be overly ambitious in this process and add more than really our bodies, our legislative bodies, or the administration would be able to accept. So just caution the members not to be overzealous in trying to get a good product out, but rather let's get something done that we can have some confidence knowing that we can get through all those processes.
I appreciate the governor's floor leader's comments. Mr. Hightower. No, I can't. Mr. Gravely, did you have something?
Just to the author, Mr. Chairman, thank you. If the author would like to withdraw the amendment and restate it minus the diagnosis that have been discussed by the author. Chairman.
I'll withdraw the amendment, Mr. Chairman.
Just to be clear, you'd like to withdraw the entire amendment 292352, is that correct?
The glaucoma.
I'm sorry, tell me, I need to just be clear as to what
the
you're...
glaucoma, line 4.
Mm-hmm. All right, so you'd like to amend your, let's just say this, you'd like to amend your amendment
yes.
by striking glaucoma and relettering properly. Any objection to the amendment? Hearing none. The amendment to the amendment is adopted. And now the question occurs on the underlying amendment 292352 as amended by striking glaucoma. All in favor of the lady's amendment signify by saying aye.
Aye.
Opposed?
No.
This is not on amending the amendment. This was on the amendment as amended. Glaucoma has now been stricken from the amendment. The question is on the main amendment in full, AM 292352, having been amended by striking glaucoma. All in favor of the lady's amendment? Mr. Setzler.
Just for members of the committee, is it true, Mr. Chairman, that the next vote will be to adopt or not to adopt the body of this amendment with a couple changes that the lady made?
That is correct.
So we're now voting on the underlying amendment to being appended to the bill. Okay.
I thought I said that.
Okay. Just want to be very
okay. No, clarity is best. The vote occurs on the underlying amendment at AM 292352. All in favor of the lady's amendment signify by saying aye.
Aye.
Opposed?
No.
In the opinion of the chair, the noes have it. Is there an ask for a hand vote? Hearing none, the amendment fails. The next amendment in front of you is AM 292353. Mr. Trammell, is that you?
Mr. Chairman, I would offer amendment.
Mr. Trammell offers AM 292353. Mr. Trammell.
Thank you, Mr. Chairman. The purpose of this amendment...
Chairman, could you have him speak in mic? I can't hear him over here.
Is your button pushed, Mr. Trammell?
It is, Mr. Chairman.
Might have the mute on the back.
Is that better?
It is.
Thank you, Mr. Chairman. The The amendment, what the amendment does is at lines 98 through 102 in the bill, there is a provision for disclosure of information collected by the Department of Public Health, which would include confidential medical health information. This amendment just clarifies that for purposes of disclosure to peace officers, that would be limited to the purpose of verifying that an individual is in possession of a registration card or determining that they're properly registered to be in possession of low THC oil pursuant to the code section. It's basically just designed to protect medical health information of the patient.
And so what it's doing is prescribing the specific uses for the exception for law enforcement.
That's correct, Mr. Chairman.
Okay. Questions or discussion with the author? Mr. Coomer.
Thank you, Mr. Chairman. Mr. Trammell, I'm just reading this for the first time, and I apologize for that, but help me understand. Would your amendment require that law enforcement would make a written request for this information before they could take any law enforcement action? Is that the gist of what this does?
It wouldn't require. I don't think they would require them to make a written request. What it does do is it limits the type of information that the Department of Public Health would be authorized to provide in the absence of a subpoena.
So is the concern that the way it's written that the law enforcement might obtain information beyond just whether or not there's a registration and authorized registration card, like, for example, some other disease that the person may have or illness that they're suffering?
Medical information that would otherwise, but for a statutory authorization allowing the disclosure of that information, would be protected by HIPAA. So this is designed to basically make sure that it's limited to the purpose that law enforcement needs and not provide diagnosis about what types of conditions that the patient may have.
Have you talked to any of the prosecuting attorney's council or any law enforcement agencies about this particular amendment?
We shared this amendment this morning. I don't know what the position is.
Mr. Chairman, if I may, I did have some conversations with the district attorneys about this. They did not seem to give any indication they had any problem with the amendment, and I don't either. I think it's probably a...
Mr. Porter, Mr. Spayhouse, you want to be recognized for a moment?
For that.
I think the gist of what this does is prevents law enforcement from getting a list of who in Henry County has a card, coming back behind and verifying the card. So that's fine. I don't see it hindering our ability to sort those cases out.
Thank you.
And I would be supportive of the amendment.
Thank you. Mr. Setzler.
Thank you, Mr. Chairman. I guess I'll ask this to the author or to the committee as a body. Isn't it true that we have a prescription drug monitoring database that came to this committee 3 years ago with significant debate and discussion that allows access to practitioners and allows fairly broad access, although controlled, not open to the public, but controlled access to the quantity of prescription drugs that someone has been prescribed. The amendment, as it's been offered, would allow someone to be designated as a card holder, or that they're in possession of it, but the quantity of what's in possession would not be available to law enforcement if this amendment should be passed. My concern is, and I may be wrong if someone reads this differently than I, but as I read this, this amendment would allow law enforcement to know if an individual has a registration card, and that if they're possessing it, but there's the ability to say how much they have, how much they've been prescribed over time, perhaps across a number of doctors, would not be available. My concern is that, as I understand, we've got an opportunity to have up to 20 ounces in the bill. 20 ounces of CBD oil or cannabidiol oil has a THC content, right? 20 ounces would have a THC content of an ounce of THC. I had, in the ensuing week since we've had this discussion, I did talk to the crime lab director at GBI. I mean, it's a fairly simple process to distill out THC from cannabidiol oil. You bubble ethanol through it, you create a honey oil with about $2,800 to $3,000 an ounce drug value. I'm just concerned, and I mean, we're opening this system up dramatically anyway, and I think there's some good reasons for that. That's why you've got the bill. I'm just concerned if law enforcement can't see the quantity folks have been given, that there's no ability for them to see who perhaps, in a way that's repugnant to what you're trying to do, Representative Peake, is acquiring a large quantity and perhaps is not doing the right thing with it. Yeah. I don't know if PAC has thoughts about that. I just wanted to kind of share that for.
Based on the way I read this, I don't believe that's the information they would be obtaining.
Okay.
This card would simply authorize an individual to possess an amount. The code section sets the amount, which is 20 ounces. So there's not going to be, for instance, we do hydrocodone, you could have a search strength and number of pills. The data that's going to be obtained from this search is simply you do or do not have a card. It would not regulate how much you have.
If the amendment were to pass, correct?
That's right.
No,
Either way, even if this amendment doesn't pass,
Right.
I don't understand the Department of Health to be regulating or keeping up the records of individuals and how much they can have. That's simply the fact that a doctor has said they have a condition, they could be treated with this, and the health department has issued that document, and that's what we would be obtaining with this provision.
Are the quantities and the prescriptions for this going to be managed in our existing prescription drug database is a question I've got then. So this, the rubric we're setting up here, the system we're setting up here is outside of that prescription drug database?
That's correct.
I mean, we've got Schedule, it's not just all Schedule 2, we've got Schedule 3 and 4 and stuff in the prescription drug database. Is there a reason that this isn't going to be in this? I mean, and I know, I'm not fighting your bill, Representative Peake. I'm just trying to, from a management perspective, if we've got all these other valid drugs in the prescription drug database, should this not be subject to the same oversight?
I believe there are enough safeguards by putting a maximum amount of. I mean, what we're putting in here, Representative Settler, is if you have 21 ounces in your possession, you're going to be potentially going to be convicted of a felony and spend a minimum of a year in jail. So I think those are the safeguards to make sure that there's not a significant amount.
And Representative Peake, I'm not fighting your bill. I just know we spent great effort in this committee to control drugs that are probably in my home right now, Schedule 3 and 4 drugs that are. Mr. Chairman, I just don't understand why we're going to have a less rigorous oversight than we would for garden variety drugs. It just would seem to need to be consistent.
Let's allow the committee to express itself. Any further questions on the amendment AM 292353 of the author? Seeing none, all in favor of the gentleman's amendment signify by saying aye. Aye. Opposed?
No.
Let's try that again. Because I didn't get half the number of people that are sitting at this table. On the gentleman's amendment, AM 292353, all in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed?
No.
The ayes have, and the amendment is adopted. The next amendment is AM 292354. Whose amendment is that? Is that yours, Mr. Grabling? All right. Mr. Grabling. Okay. Mr. Grabling is going to withdraw his amendment, AM 292354. The only other amendment I see here printed.
Mr. Chairman, I would take that amendment up, offer that amendment 2354.
All right, Mr. Trammell, I'll go ahead and recognize you for that purpose.
Mr. Chairman, this amendment seeks to add some language that would make clear that a mail order delivery of a single package of low THC oil to a patient registered would not be a violation of the code section.
I understand the inherent intent of where you're going on that. While not stating it, I think what that ends up doing is it is a tacit endorsement of a violation of federal law, which I know is not the gentleman's intent. I get that. But if you take a hard look at it, while it may be immunity for this particular section, what it ends up doing is tacitly endorsing a violation of federal law. I'm not sure that would be a good path for us to take.
understand, Mr. Chairman, the concern. It was set up to provide an affirmative defense so that to the extent it wouldn't have a chilling effect on someone who want to do that.
Yep. And your heart's in the right place, and my heart is with you. But we also know that that's going to fly us right into a buzzsaw of federal law. Does the gentleman disagree?
Mr. Chairman, I'll defer to your judgment and respectfully withdraw the amendment.
I appreciate the gentleman. Thank you. Okay.
One more.
We have one more amendment, AM 370268. This is the immunity language negotiated between the Hospital Association and the trial bar. Is that a correct statement?
Yes, correct.
Who's offering this amendment?
I think Representative Strickland is, I think.
Mr. Strickland.
And as the chairman was stating, this amendment deals with civil and criminal liability for a hospital, medical facility, or healthcare provider where someone's actually taking the low THC oil or being given that oil on premises. And I think there are a couple changes that Legislative Council has on this last draft, as well as told.
Yep.
I do not have all those with me.
Mr. Chairman, the heart and intent of this amendment is this. We wanted to make sure that if we had a family like little Hawk over there and his mama who went to Children's Hospital and they, by law, had access to cannabis oil, had it legally in our state, wouldn't potentially have the problem of having the hospital turn them away because they were accessing cannabis oil legally. And so that was the heart and intent of this amendment. So.
Is it my understanding then that the amendment is not quite perfected? Is that a fair statement?
The problem, it's close, and I
Okay.
can do it probably on the fly. The problem is
No.
this was drafted before the bill was, I think, before
Or
the
the
bill
final
was-
version, right.
And so it uses words like extracted cannabidiol or cannabidiol oil rather than low THC. It doesn't deal with.
Right.
I mean, I've got them written down on.
Let's do this. My sense of it is that it's a non-controversial amendment between folks in the medical community and the legal community.
That's right.
I don't want to legislate on the fly in general, definitely not on this bill.
Okay.
So what I would recommend is that we save it for the floor under a modified structured rule with everybody who cares to sign it, including the author, including the chair, including Mr. Strickland, and whoever else wants to sign it. And I don't perceive a problem. How does that strike the author?
Well, I had probably intended to ask the rules chairman to have it as a structured bill.
Well, if it's modified structure, it's only those amendments that are approved by rules that will
in the
actually
Rules
go onto the
Committee.
floor.
Okay, all right.
So
Okay. Yeah.
that would limit the number of amendments to this one.
Okay. Yes, sir.
That would be it.
And I'm good with that.
Okay.
Yes, sir.
Mr. Strickland, are you good with that?
I'm good with that. I'll withdraw
Okay.
the amendment.
Let's do that. Let's go ahead and withdraw. Mr. Strickland's going to withdraw AM 370268, but we'll see it on the floor. Clean up a little bit. Mr. Hightower.
For purposes of this committee, if we
Sure. Do the thing on the back. There you go.
Is that better?
Yeah.
For purposes of this committee, I know we're not trying to draw it out very long, but if we know that that's amendments coming, you want to possibly talk about the amendment now, even though we know there's going to be some changes. It seems like they're very minor
Yeah, I think it's a good idea. Thank you for suggesting that.
The only reason I draw that out is because the way that I read this is not a shield necessarily for the hospitals to say we don't want to be penalized if we administered this. This is just for the parents. Is that this an immunity for the parents themselves in a way, or is this an immunity for the hospital?
Mr. Strickland,
And that is correct. The way the amendment is written, it says a patient or a caregiver providing a patient the oil. So it deals with those in the facility actually using the oil, whether it's a patient or someone caring for them, not the hospital itself. The idea, again, as Representative Peake was saying, we don't want to put in the hospital position of whether or not they want to stop this from occurring on the premises. This just says we're going to pass this law, we're going to make this legal hopefully pretty soon, and we're going to say this can happen on your premises. But we're saying only by the parents. In other words, if we're not giving the hospital immunity if they administer it, correct? It's just
that's correct. A patient, or in the case of a minor, the patient's parent or guardian or caregiver.
Yeah.
Okay.
I think the hospitals don't want to give it.
That's right.
They don't want to be in a position doing that, but they don't want to also.
Okay.
They also, just as any patient when they come to the hospital, the patient the hospital has to deal with them with the condition that they're in.
Sure.
And so we want to make sure that it wouldn't preclude them from providing them service if the patient was in possession or need to continue to have possession of cannabis oil.
And I realized that's what the amendment was doing. When we had our first debate on this, we talked about possibly hospitals were wanting to be immune if they were to diagnose this, and I didn't want people to think that we're holding this amendment in a way to possibly, shield a hospital, because that's really not what's going on here.
That's correct.
This is only with the parents or the patient or the minor's parents, and the reason for that is because the importance of drawing the distinction for me is if we were to shield hospitals in their diagnosis, there'd be no motive to perfect the industry or to perfect the diagnosis of once you give this to someone.
Right. And I appreciate you bringing that up last meeting too. So you good? Mr. Pack.
Thank you, Chair. Continuing with the amendment, as I read it, it looks like the Title 16 portion of the committee substitute immunizes possession only. Am I right?
That's correct.
It's not dispensing.
That's correct.
And so this amendment would expand that by excluding liability of dispensing as well.
I don't know that that's the case, Representative Pike.
So,
because the hospital would not be dispensing it. I mean, all their.
Mr. Strickland, do you want to speak to that?
What it says amidst.
What line?
Oh, okay. So it allows. So in other words,
It allows the possession of.
If the parent possesses it at the hospital, the hospital is not liable.
That's correct.
That's right.
And if the parent chooses to give it to their child in the hospital's not liable.
It has to be the patient or the minor patient's guardian doing it.
Two things, just a commentary, and this is not my amendment, and I apologize for being late. One is I question whether or not we should have a criminal liability in the statute, the immunity for criminal liability in the tort statute. And second, with respect to the language in line 20 to 21, Mr. Strickland, I'm not quite sure what good faith belief that was in accordance. I don't know practically how that would work. You either decriminalize it, saying that it doesn't matter as long as it's in accordance with the state of Georgia law, which in this case, so it's actually a mistake of law defense that you're creating. The way I look at it, it might be better just kind of say, the hospital will not be criminally charged for someone who dispensing in accordance with the statute cannabinoid oil, period, instead of putting a scienter requirement onto the statute.
Mr. Chairman, I'm stuck in between two lawyers, which is a dangerous spot to be.
I think it's a good dialogue, but what it definitely proves out is that there's some more discussion that has to happen on the amendment to get a consensus on it before going to the floor, which will have to occur before it does go to the floor.
Yes.
So the quicker the amendment is straightened out, the quicker House Bill 1 can make its way there. Ms. Cooper.
This is not, I think, about hospitals. Normally, hospital procedure is that patients cannot take any kind of medication that they bring in from the outside unless approved. And so this is data.
No, this is a withdrawn amendment. We're taking a last bit of commentary, and then we're going to a vote. We have to move on.
Am I right that that's what it was covering, because the physician won't be able to administer, the hospital then won't take responsibility for administering it, and normally they would ban any type of medicine like this being given by a parent or child in the hospital.
That's correct.
Right. So this is making an exception to that hospital rule of where they don't allow any medicine to be given.
That's correct. Yes, ma'am.
To the patient except at the hospital.
That's correct.
Okay.
Yes, ma'am.
That amendment is eminently doable. It's just a question of crossing the T's and dotting the I's on it. So we withdraw the amendment. We'll see it back on the floor under the modified structured rule. I see no other amendments. Are there any other amendments? Are there any other amendments? Seeing none, Mr. Setzler.
Thank you. I wanted to ask Mr. Peake to that point about the prescription drug monitoring database. Mr. Chairman, I would offer an amendment in committee if I had the resources to kind of articulate that. I was kind of whispering to council earlier. I don't think I can make that happen today. I would ask the author, just in principle, is there any reason that we wouldn't want CBD, THC in this setting to be part of the prescription drug monitoring database like other scheduled drugs?
I think if it involves a full-scale in-state infrastructure and regulatory structure, what we're looking at possibly doing in the future, that yes, that maybe that's something worth doing. In this particular very limited bill that we're looking at today, I'm not sure that it's necessary.
Is this subject to any oversight by Georgia Drugs and Narcotics at all in terms of their standard? And this is a question to council, Mr. Chairman. Does GDNA have any oversight or authority over what we're voting on here today?
Not according to this bill. It's under the Department of Public Health, and then medical oversight by the Georgia Medical Composite Board.
I'm just thinking out loud, Mr. Chairman. Just to understand, are there other carve-outs that are medically employed drugs that candidly have an important impact? We wouldn't be voting on this if there wasn't an important impact here and it wasn't important public policy. Is it appropriate to have GDNA ability to oversee this? That they're in that business. That's what they do. And is there a reason that we couldn't have? I mean, and the reason I'm asking this, Mr. Chairman, is perhaps a floor amendment to say that this is monitored in the same prescription drug monitoring database that we monitor other scheduled items.
I think it's a legitimate question. That being said, that probably begs for a deep conversation with Rick Allen over at the Narcotics Agency to get our hands around. I mean, right now I'm in a posture, I've got a motion, I've got an amendment adopted and ready for a vote. I'm not saying that's not a potentially relevant point, but in the absence of a printed amendment, I think, but there certainly allows for the possibility of a floor amendment under the rule.
And I'm willing to continue to have that discussion with you, Representative Seltzer, see if it makes sense.
And again, there's the GDNA issue, what their role would be or should be, and then there's just the monitoring database piece that I just want to let you know, get your thoughts. If you're potentially friendly to that, offer as a floor amendment as well, Mr. Chair.
I'm willing to have some discussions about it. Sure.
Okay, thank you.
Thank you. On the underlying motion of do pass by substitute, and we were saying by substitute, I think that which makes it structurally easier for council. On the underlying motion of do pass by substitute, which contemplates the one amendment, two amendments that were adopted, I apologize. All in favor of the motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Mr. Peake, thank you.
Thank you.
And we will see you on the floor.
Mr. Chairman, if I can just...
We've got to...
I just want to take an opportunity to thank you for your work on this bill, and Jill Travis. This is not an indication of a slippery slope, but in my mind, a verification of a compassionate reach to our citizens. And so thank you, members of the committee, for moving forward.
Thank you, Mr. Peake. We're going to take 5 minutes. 5 minutes. A real 5 minutes. right now, Mr. Belton. Let's go ahead and continue our meeting with House Bill 103. Representative Belton.
Yeah,
Okay. Okay, thank you. Mr. Belton, welcome.
Thank you, Mr. Chairman. I've asked Randy Upton, the father of Kelsey Upton, to accompany me, as well as Chuck Spahos, the prosecutor's attorney counsel, who helped draft this bill. Mr. Chairman, 85% of teens have a social networking account. Most internet sex crimes involve minors. In 82% of those cases, the offender used the internet to find the victim. So personal information on the internet is a threat to teens. 33% of teenagers have been victims of cyberbullying. 1 million children have been harassed on Facebook alone. 1 in 7 kids, this is amazing, 1 in 7 kids received a sexual solicitation online. At least 8 million children go missing every year. So personal information on the internet is a jeopardy to teens, and some of them, many of them, commit suicide because of this bullying. Mr. Chairman, this is a very simple bill. It states what every one of you probably already believes, that it should be illegal to post a minor's personal information on a pornographic website. This happened to a minor in my district, Kelsey Upton, who, through no fault of her own, she was not texting, she was not sexting. The picture was not even of her, but another girl, but she found that her name and phone number and her a picture were plastered on a pornographic website on a picture of a nude girl who looked just like her. It took her father, a former GBI investigator, no time at all to find the perpetrator, but when he found the culprit, he discovered there was no law in Georgia to prosecute him. That needs to change. I direct you, sir, to Lima Charlie 296382 Sierra, line 14. A minor is a person under age 18. Nudity, and number 15, is set forth in the code already. Line 16, obscene depiction is, we're saying, is a means of visual depiction of the individuals displaying nudity or sexually explicit conduct. Line 18, we're saying that the sexually explicit conduct has already been defined in the code. Line 20 is the meat of the matter. No person shall intentionally cause a minor to be identified as an individual in a obscene depiction in such a manner that a reasonable person could conclude that the image depicted was that minor. Line 23, we're talking about the information, the minor's name, address, telephone number, email address, username, or other electronic identification. And line 24, we talk also about facial image in case of photoshopping, which happens, of course. Line 26, we're saying that the first offense is a misdemeanor. Line 28, we're saying that the second offense is a felony. Line 37, saying it does not apply to activities of law enforcement who are trying to find sexual predators. Or also, number 40, identification pursuant to a civil action. Sir, this is actually the third year we've run into this. Representative Pam Dixon started this progress, and then Representative Doug Holt. If we protect anyone, we should be protecting our children. New York, Missouri, Rhode Island, Maryland, California have all passed laws against cyberbullying. At least 45 states have passed laws against digital harassment, and I think Georgia needs to join them.
Thank you, Mr. Belton. Let me ask Mr. Setzler for a subcommittee report.
Sure. We move this forward from subcommittee with a unanimous do pass recommendation by substitute. The committee did make some changes to the bill, had great testimony last week in committee. Spent about an hour on it, kind of working through a couple minor changes, and came with a do pass recommendation, Mr. Chairman.
Questions for the author? Seeing none, thank you, Mr. Belton. Would anyone like to be heard on House Bill 103? Anyone here to be heard on House Bill 103? Yes, sir.
Yes, sir. If I could just make a quick comment.
If you could Thank you.
Randy Upton, I just clarify a couple of things. When this was first brought to our attention, actually the district attorney directed to the GBI, and thank God the GBI was actually involved in the investigation, identified the individual, and once they've identified the individual, they determined that there was no laws that he had broken that they could attach to the individual. Secondly, after I found this out, Representative Dickerson stepped forward and sort of helped my daughter through a very difficult time, and I want to thank her for that. And then also Doug Holt and the others that have stepped in, and the board here for. I told somebody recently I really respect what the process, because I know that it's difficult to get a bill through, and when I saw how they were analyzing, sort of making sure everything was correct, it's just made me realize that you're taking it serious, and I really, really appreciate that. And I feel that having talked to parents of kids that have committed suicide that didn't have a bill to fall back on, didn't have a law to fall back on, will help those kids once they do have a situation like this, that when law enforcement is notified, they can tell them there is now a law out there that covers them. So thank you very much, and especially Pam Dickerson and Representative Belton and Doug Holt for all they did.
I'm not surprised that Representative Dickerson was the leader on this issue, not in the least.
Yeah.
That's what happens on this committee.
Yeah, yeah.
People on this committee are leaders, and they take ideas and they run with them. And it's just a matter of time before good ideas like that become law. So it's not a surprise to me or anyone at this side of the table, sir.
Yeah. Well, one of the things she did that just was, my daughter was in high school at the time. She was number 2 in her class, and when this happened, she started struggling. Pam actually came to the school and talked in front of the school, recognized her in front of the school, and all those rumors and gossip that was out there sort of ended the day Pam came into the school. So that's why I said that I just thank her, and I owe her a debt of gratitude for that.
I appreciate your saying that. And let me tell you something. We've had legislation along these lines, different subject matter here and there with parents who have been affected, and sometimes tragically, as in your case. And I know, I was about to say I know how difficult it is. The truth is I don't know how difficult it is to be sitting where you're sitting, but it's a monumental feat of strength in my mind, and I think in our mind, to be sitting there and have been as engaged as you've been on this issue, both with Pam, Representative Doug Holt, now Representative Belton. So I know that's got to be a level of tough, of difficult, that I just can't understand. But you're an incredibly strong person for doing it, and we take our hat off to you. Honestly, we do. It's not easy. Most people would not have that kind of strength. Let's just face it. They would not have that kind of strength, but you do. So, and what you're doing here is going to benefit other people.
Yes, sir.
And that's that's the whole pay it forward.
Yes,
that's what we're here. That's what it's all about, right?
Yes, sir.
Okay. Would anyone else like to be heard on House Bill 103?
Mr. Chairman, I just wanted to say to members of the full committee that were not in the subcommittee, we did make an effort to make this consistent with other similar laws about obscene depictions portrayed electronically. The prosecuting attorney's council was very helpful there. What we did is, just so for folks to know, first offense is a misdemeanor. So if there were some youthful indiscretions, the court would have the ability certainly to sentence up to a year if it saw fit, but it would certainly not be treated as a felony right out of the gate. But a second offense, if someone knowingly do this, there could be somebody that was doing this knowingly across state lines and so forth, it would have the potential for felony treatment on a second offense. So, the idea you could have a first-time wake-up call, but the second time after that wake-up call's happened, we can handle this very seriously. Yep. And that's consistent with other statutes.
And that just makes eminent sense to me. It's a good balance that's been struck there. All right, what is the pleasure of the committee?
Second.
Ms. Dickerson moves due pass, second by Mr. Setzler of HB 103, LC 296433S by substitute. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentle lady's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Mr. Belton. Thank you.
Thank you, Mr. Chairman.
Mr. Tanner. You what?
I could hear all the gossip over here with the government affairs folks. Good. You should hear what they're saying about you, Mr. Chairman. I've heard it on the multiple times.
Mr. Tanner.
Thank you, Mr. Chairman. I appreciate it. I'm here today to talk about House Bill 71. I have a substitute that should be in your folder that I'm reading from, LC 296423S.
Let me just make sure members have that, LC 296423S. Does anybody not have that? Okay.
Thank you, Mr. Chairman. Just a quick overview of this legislation. This legislation is brought in an attempt, and we've heard through subcommittee, through 3 hearings, a lot of testimony relating to the parole board and the fact that the parole board has been in existence for 70 years, and it originally was created and given the power it has in the Georgia Constitution because of some concern that governors were selling pardons and selling various things at the time to individuals for favors. And so they set up a process that kind of removed it from the political arena and set up the Pardon and Parole Board in the Constitution, and it continues to be the case today. Like most government, though, things and the public's demands on us has changed over the years, and the General Assembly doesn't operate the way it did 70 years ago. The public demands transparency. They demand openness in their government, and for the information used and paid for by the taxpayers generally to be available for public inspection and ultimately public scrutiny. So this is the purpose of this legislation, and I'll just go through it, Mr. Chairman, and what changes we're making. The first area on the first page there, around lines 21, this just deals with the notification. If the way death penalties work, if a death warrant is signed, there's a 2-week window opened up that the person will be executed. The Pardon and Parole Board will notify, and the district attorney will notify any victims' families in the case, et cetera, about that. About the death warrant being signed, and they'll set up a commutation hearing, usually the day before the execution. So the Parole Board, the Department of Corrections, everyone gets together, determines what date within that 2-week window that the death is going to occur, and then the day before normally there'll be a commutation hearing. And this just puts in code that will occur at least 72 hours. The victim's family and others will be notified at least 72 hours ahead of time. There are some victims' families in cases who don't want to be notified. So this doesn't force notification. This just says if a victim or a victim's family has registered, then they'll be notified. Failure to the victim to inform the board if they move doesn't affect anything. The board can't control those things. There's some, the victim and their family has to stay up to speed with the parole board, and the parole board has a good process in place to stay in contact with victims. And then going on down into Section 3, this deals with the findings of the boards on pardons. Originally, when we presented this legislation and I introduced this legislation, we treated commutation of death sentences and pardons the same way. Since that time, we've broken these out in a distinct manner. This applies to pardons, lines 57. If a pardon is going to be granted, then the board, or not granted, the board will issue their findings in writing, the reasons that support their findings, and they'll indicate each board member's vote, how each board member voted on that decision, and all that information they use will be available for public inspection, so it'll become public record. In commutation of death sentences, they would provide a written basis for the decision. They would indicate the board's vote, so it would be under this draft, it would be in a vote of 3-2, the board decided to grant commutation, clemency, what have you, but not the individual board member's vote. And all that information, again, would be available for public inspection. Going on down in Section 4, this deals with if the board is going to consider a pardon, if they're going to consider commutation, they have the power to bring in front of them whatever information they deem important. But at the least, they'll consider this list of things that's already in Georgia law. Being added into that on lines 87 is written statements or oral testimony from the district attorney expressing any views or whether the person should receive a pardon or have commutation granted. Also under 7 deals with the victim or the victim's family. And then on line 95, number 8, that deals with You saw a lot of information out there in the media dealing with pardons of sex offenders. We do not have, in my opinion, and talking with folks in the Attorney General's office, talking with Legislative Counsel, and I know there's some cases now being argued in the appellate courts on this very issue. But if someone receives a pardon and they're required under Georgia law to register as a sex offender, it is the people's belief that I've talked with that they no longer have to register as a sex offender, because the Constitution says that they are granted relief from any, and I don't remember the exact term, but it's obvious if someone's required to wear an ankle monitor, that's probably a hardship and probably is going to be found to be so by the courts. So what we wanted to do is say here that the board will consider whether or not the person has tried to go through Superior Court and the process to be removed from the sex offender registry. So if the person is having to register as a sex offender, then the board takes that into consideration. Doesn't say the board can't grant them a pardon. It just says they'll consider that information. And then over in lines 111, this deals with giving notice on pardons. We heard testimony in subcommittee about district attorneys who have found that someone that they had prosecuted, specifically the district attorney from Savannah testified about a child molestation case. They found out later the person was not registering as a sex offender. When they reached out to that person, they said, well, I no longer have to do that because I've received a pardon. And when they started checking, they found out that was the case, but the prosecutor had no knowledge of that. So this basically just states that the parole board will notify the prosecuting attorney's office they're considering a pardon and give them an opportunity to be heard, just like they also will notify the victim in the case and give them an opportunity to be heard on that case, whether or not they should grant a pardon. And then going on down, some language dealing with they can have a hearing on any of these cases. If they're considering parole, a pardon, commutation, the parole board can hold a hearing, gather any information they deem necessary for their consideration. And then I think the next real substantive change, other than some cleanup there, is on lines 188. This is the area that basically once a final decision is made and a pardon or a commutation, once the board has reached a decision, then the information, all the information they used and relied on to make that decision becomes public. It's open to the public. People could do open records request and get the information. It's not the way it is today. Those things are still under state as a state secret. We have 4 exceptions to that listed in the substitute before you. Exception 1 was statements or information provided directly or indirectly by the victims or on behalf of the victims after the date the defendant was sentenced. We all know that the victim impact statements are all public record now. That, of course, doesn't change here, but the reason for this is due to the very sensitive nature of some of that information that's provided by victims. And that's there. And then any information provided pursuant to Code Section 42-5-36. Now that's dealing with information surrounding an inmate who may give information on another inmate. Those records are in Department of Corrections files. The Department of Correction turns that information over to the Pardon and Parole Board, and we don't want to put any of those inmates in jeopardy because of that information that might be released. In the same way with number 3, dealing with information the Pardon and Parole Board gets from the Department of Corrections that could jeopardize the safety of their facilities. And then the last is something that in the current substitute that was approved by subcommittee, there was a change made. This addition was made. This substitute I bring before you tweaks that change. It was made in subcommittee to say any internal communication among board members. Chairman,
can you point that out for us?
Yes,
that is material change between the subcommittee version.
Yes, it's in line 201.
Okay.
201 and let's see if I have it here. And the what's in the subcommittee approved version was any records, documents, or information pertaining to internal communication among board members. And the reason for this is, and Chairman Setzler and I have had a lot of conversations about this issue, the idea is we don't want to get to what the board members thinking, how they're reaching their own individual decision. Maybe if they are making notes or sending an email to another board member talking about, hey, what do you think about this pardon? Kind of, I think Chairman Setzler said how the brain part functions between the board members. That's not what we're interested in. And so we want to still protect that information, but we want to be careful that we do it in a very narrow way so that we don't open this up for the ability for a lot of other documents to be labeled as internal communications, which could undermine the whole meaning and purpose of this legislation. So, and I don't think I've not heard that from any member of the committee as that being their intention. So that's the reason for the change. And I worked with the Prosecuting Attorney's Council on that and Legislative Council and talked with Chairman Setzler and trying to come up with something that gets our intent but is narrowly focused. And Mr. Chairman, that's in essence the legislation. I'll be happy to answer any questions.
I'm going to go and call on Chairman Setzler for a report of the subcommittee, and then I'm going to ask Ms. Travis for her observations on a couple of issues that she may have discovered.
Thank you.
Thank you, Mr. Chairman. As the author said, it was the 296422S version that passed out of subcommittee. Again, the difference is on line 201 and 202 versus line 201 of the 2.3 version. I think the discussion in the subcommittee was, as Representative Tanner said, the idea that the brain, if you could think of the board, the brain function, what's happening within purely internal to the board would not be publicly disclosed, was the subcommittee's intent. The subcommittee did, in passing it forward, postpone consideration on one amendment, which we can, at the chair's pleasure, talk about today, which was the handling of information and what's disclosed with respect to votes, particularly with respect to death penalty. I didn't want to be in a posture where the subcommittee is passing an amendment that gets unamended in full committee because the full committee wasn't aware of it. So we postponed consideration on that. And I just, if it pleases the chair, we'll have an opportunity to discuss that today.
Sure. Let me call on counsel for 1 minute, then we'll go back to that issue.
I look at these bills a million times, and I understand the author's intent, but sometimes something triggers when the oral presentation is being made. And I was recognizing, as Representative Tanner was presenting the bill, that he was very clearly saying we're looking for openness and transparency, and these granting or denying of the parole. Well, actually, the words we have in a couple locations only make it as a grant, and I think we meant to have both sides. So directing your attention to line 55 and 56. At the end of line 56, I would just put relating to and take out the word granting on line 56. On page 3, at line 89, I would take out the granting of. And on line 93, I would take out granting.
Oh, 89 and
89 and 93.
Yeah, okay.
And then on line 113, I would take out to grant and replace it with the word on. Final decision on a pardon. What brought that to my attention was specifically with the district attorney wanting to be able to make a recommendation. Really, he's going to want to make a recommendation whether it's to grant or to deny, right? So that's why I wanted to.
Let me have you just repeat that, just for make sure that the committee has that clear. It's striking granting on line 56 and inserting related to.
Relating to.
Relating to. On line 89, striking granting of.
The granting of.
The granting of.
On line 93, just striking granting. And on line 113, take out to grant and replace it with the word on. My apologies.
No, not at all. Thank you for catching that. I think what the chair will do, putting the author on notice, is that we'll go ahead and I'll offer that as an amendment after a motion.
Thank you, sir.
Okay. Mr. Setzler, did you have anything else that you wanted to? Did you have a question for on a follow-up
Just
on the issue that you made before.
Just the appropriate time, I did want to discuss sometime during the hearing the issue of what's disclosed publicly with respect to the board votes.
Well, let's get into Q&A with the author at this point, so why don't you just go ahead and leave that off.
Okay. See it. I shared with the author, and I also shared with members of prosecuting attorneys, counsels, and others. And I think in the debate I've shifted some in terms of my policy proposal. And that's one of the reasons I wanted to have some more discussion after subcommittee. I think the issue, one of the things the author brought when he proposed the bill was providing clarity and finality, but in an overarching way that the openness is what this bill's about. We provide an open. We've I think done a very meaningful and extraordinary job of opening up any document that flows into the board and those kinds of things in these proceedings. I think with respect to commutations of the death penalty and the consideration thereof, I think as the author recognized in offering this initial substitute, publishing the names of votes for death penalty commutations, it is a different thing in kind when you're dealing with the death penalty than other things. It's handled separately in the sentencing phase. We understand that very well throughout the process. I shared with prosecuting attorneys counsel a concern that in something that is final and is big as the death penalty, there's nothing more substantive that we as the legislature do than how that's managed. And I shared a concern that if this legislature sees fit to not publish the names of the members, which I think the gentleman in offering the bill is wise to not do in a commutation of a death penalty circumstance, I see a problem in the publishing the vote to create a circumstance. I would argue that if you come down with a 3-2 vote on a decision to allow the death penalty to go forward, does that create an inference against the vote that if the board typically, just by happenstance, acts in a 5-0 way and a 4-1 way and a 5-0, and all of a sudden a 3-2 vote comes up, even though there's not individuals' names published on death penalty only, not talking about pardons, does that not create a circumstance where public confidence could be shaken in the final decision to move forward with the death penalty? I think I've got some grave concerns, and I've shared with prosecutors. I think as long as the state's going to have a death penalty statute and have a structure where it continues to receive public confidence, I think the gentleman's concern about publishing the names would warrant, and out of abundance of caution, is this step. We can always go back and change it. But in this step, have as the gentleman said, have the purposes and their findings, the general findings published as the gentleman provides. But that 3-2 score, if you will, the death penalty only, not being made public because the death penalty is different. And out of abundance of caution.
I mean, I'm going to kick to the author in just a second, but I can see the gentleman's point as it relates to the individual board member's vote. Candidly, and to be philosophically consistent, there is a great argument to be made that it all should be public. The name, whether it's death penalty or whatever it may be, judges do it all the time. Their names are on the line, and oh, by the way, they run for office, including the appellate courts of the state and the state Supreme Court, who also runs. These parole board members serve for 7 years. They don't stand for election, and the only way they're going to leave office involuntarily is by impeachment. So, speaking just for the chair, my personal feeling is that it all ought to be on the line, name, including the name, and if there is some sort of problem with an individual member not being ready, willing, and able to do that, then they don't have to serve in that position. That's ultimately an individual decision. That's not a glib or flippant statement. It's a very grave position. If they don't think they can go ahead and handle that, then that's their discretion to step aside. That being said, as the debate has percolated over the last several weeks, I think there is at least, if not more, a tacit acknowledgement that the death penalty is a different animal for sure, and that we step back and, all right, if we're not going to go ahead and require the individual board member to sign his or her name on that vote on the death penalty commutation, then the threshold question to me becomes, what really is either the institutional harm or societal harm, if any, in just publishing the vote count? I personally don't see the harm. I'm willing to be educated otherwise, for sure. I don't see what harm occurs by virtue of the vote count, because the decision is the decision, whether it's 324-150, whatever. That's where I'm at, and I'm trying to wrap my head around what the real harm in that is, especially since we're carving out an exception on individual identification of a vote for the death penalty in deference to some people's concerns. And I'm going to kick to the author and get his thought.
Well, my personal opinion has not changed from the time I drew the legislation the first time. My personal opinion is that individuals who are in positions of authority within our government should always be willing to make a vote, to make a decision, and have that stand for public scrutiny, period. Whether it's the death penalty or whether it's pardons, paroles, whatever it is, being a legislator and having to vote on a transportation bill, they're tough decisions. And I believe that if you accept the position, because we're not forcing any individual to do this job, if you accept the position, you should be willing to be open and transparent. That has not changed. I believe that today. But through the process of legislation, we don't always individually get what we necessarily think should be the way it should be. So through working with the individuals and the parole board and understanding their concerns, specifically as it relates to the death penalty, then we made the change to the death sentence that the individual votes would not be published, that only the board tally vote would be recorded. And I stand by that. I think that I can understand where the individual board members are coming from, and I understand their concern. I may disagree with it, but not so strongly that I wasn't willing to bring forward a bill that carved that out and said that only the individual board members would be known in pardon cases. So, Mr. Chairman, I stand by the draft as it stands now, that I think that this is the very least that we should provide to the citizens.
I would concur with that, and I just don't see that it's been enunciated as to what harm occurs by having the number 324-150, whatever it is. I don't see that. I'm willing to be educated otherwise, but during your conversations, was there? Can you? Not that you should argue against your position. I'm not asking you to do that, right. But if the issue is to be vetted by the committee, any thoughts along those lines? I don't see how it's. I'm not even sure it's relevant, but
I've not had any. I mean, I understand Chairman Setzler's point, and that it may cause pause to maybe an individual board member deciding how to vote. It may open up the board's decision possibly for somebody to say, well, wait a minute, in this case it was a 5-0 vote, in this case it was a 3-2 vote. What's the difference in circumstances? And this person was executed based on one vote away from not being executed. But the reality is a lot of the greatest court decisions ever rendered in this country that we all live under were 5-4 votes by the Supreme Court. A lot of the decisions made in the Georgia Supreme Court that affect all of our lives are votes that are close. And in those cases, the vote is recorded and we know which justice voted how. And the chairman pointed out, even our Georgia Supreme Court stands for elections. So they have less protection, in my opinion, than the Pardon and Parole Board does, because they're there for a set 7-year term.
Mr. Setzler and then Mr. Pack.
Mr. Chairman, let me say for the record and emphatically, I have zero concern about the feelings of the board members. I have zero concern about their discomfort. I have zero concern about any interest they may have outside of serving the public interest. The proposition I'm suggesting is all about the institution and about the integrity of the recognizing the human dimension of the process and recognizing beyond that, setting the human dimension and all that aside, is the public integrity for the institution itself. And we have there a lot of the discussion in subcommittee centered around: is this a judge? Is this like more like a 3-judge panel, or is this more like a jury? Jury deliberations certainly are not disclosed. You've got, in this context, you've got people who are professionals and they're paid. But from the standpoint of the institution, I would share to you, Mr. Chairman, what's going to create the greatest public confidence in the institution and in the decision is broadcasting uncertainty or providing closure what we want as a state. And I'm concerned that publishing a score simply broadcasts uncertainty and undermines the institution over time. And that's my concern.
And we're just going to have to agree to disagree, because we have that uncertainty in the law every day with 4-3 decisions coming out of the Supreme Court, 5-4s coming out of the U.S. Supreme Court. But that's the rule we live under, and that's the standard that we have, and so far the sky hasn't fallen. But I understand the gentleman's concern. It's not just a legitimate concern, it's a heartfelt concern about wanting to make sure that those core foundations of an institution don't get weakened. It's just that we disagree on, are they actually going to weaken it, and I don't think they will, personally. Mr. Pack.
During the subcommittee with Chairman Sessler, I think there was a vibrant debate about the balance that I think we're trying to strike here. One thing that struck me as kind of odd, for all due respect, I think the court and judicial decision-making system and the written opinion is completely different from this process. And I look at it in two ways. One is, I think the bill and the why the system was built this way, I guess, for the last 70 years, was to protect the decision-making process. In a jury system, it seems to me that there's some magic that happens when you get a whole bunch of people together to discuss something, and then voila, and then you have a decision one way or the other, and you don't know what happened. The parole board seems to me a little bit different, yet the testimony was that they individually make a decision, so that each decision is not influencing others. And I think the fear, at least the concern that I had, and I'm sure that people could disagree, and I believe in transparency as well, that we are applying different standards, different circumstances to make them apply to the same rule in a situation that's completely different. We all know that judges write opinions because that, and the way they write it is so that it could serve as stare decisis for future decisions. And I'm afraid that in the context of parole board, if we started doing that, opening up the process, and I agree with Chairman Sessler on this, they will add more confusion and lack of trust in the process than the ambiguity than actually going towards more of a confidence model. And I guess we'll have to see. And I support the bill. I'm just voicing a concern that I think we may have some unintended consequences of something. If we have a parole board made up of 5 people right now deciding one case one way, and then they issue a decision, and you know how the vote went, and some of the open records and the findings and things like that. 10 years down the line, in a very similar situation, when the parole board is voting with different composition of people, I think what you're going to have is that previous legacy parole board's decision influencing the way they rule subsequently. And that's something that I fear, because I think independence in those board composition is something that we should preserve.
Well, I don't dismiss the gentleman's concern, but that presupposes that the board 10 years from now is somehow bound by the principle of stare decisis, and it is not. I mean, the gentleman must agree with that. It's just not. And you're going to have, and we have them now, and correct me if I'm wrong to the author, we have situations now where you could have fact patterns, and of course there's no 2 identical fact patterns, we get that. But you could have 2 very close fact patterns, and yet the board will make one decision one way on one set of facts on one individual and another one, when you'd think, just taking a giant step back or looking at it from 30,000 feet, that would be the same decision, but it's not. It's not. And that's why we have them, and that's part of the subjective nature of the job. I don't dismiss the gentleman's concerns; they're legitimate. But the question is, where do we err? Which side do we err on? I support the bill as well. Again, I don't dismiss those concerns. We do have the ability to come back, whether it's 1 year, 2 year, 3 or 5 years, and make some adjustments according to what we see. And frankly, the feedback that we get from the board is not the enemy. That's right. The board is a tough job. and thank goodness they're there to do it. But as my hope is that as we get that experience and it goes along, and things are working great, but some things are not working so great, my hope is that the board will go ahead and come back to us and say, look, I know we thought this was going to occur, but here's what's really happened, and get educated about it and potentially do something. And that's the beauty of reform. Reform is never a one-year process, not real reform. Reform is a multi-year process. Mr. Setzler had another comment, but let me ask, is there any other member of the committee that's got a question for the author? Seeing none, Mr. Setzler, I'm going to recognize you one more time, and then I'm going to ask if anyone else has any testimony to offer before we get to a motion.
Hey, Mr. Chairman, and to the chair's point, we're advised to take important and measured steps, and I think this takes a very important step, and I commend the author for it. As the chair knows and as members know, even those that weren't in subcommittee, in offering the bill, the gentleman, in essence, created a process that's been very much not open in any capacity over the years to something that is completely open and perhaps more open than a city council meeting. It's all's laid bare. I think the 70-some years ago, when the decision to tighten the process down is a very different time. I don't know that we're advised to follow that approach, but I do think as we take this step, if the bill as originally offered is taking 100 steps, are we advised to take all 100, or are we advised to take 96 or 97? And I think what I'm suggesting, Mr. Chair, is the author recognized the internal communications piece as perhaps could be tweaked. I'm simply offering that we take 96 steps in a very positive direction that we can be very proud of, but perhaps not going on 100. And because, as I would suggest, some things are undoable, and I think if we take an intermediate step and feel like we need to do more, we're advised and can certainly do that. I think we take 100 steps, it's done forever. And unintended consequences couldn't be undone.
No, I mean, this is a serious change. This is a serious change, and I think it's a productive one, and the process is, if there's ever a bill that I think the process has worked, it's this one. Of course, it's early. So. Is there anyone else who'd like to be heard on House Bill 71? Going once. Okay. What's the pleasure of the committee?
I'd like to make a motion.
Ms. Ballinger.
I would like to make a motion that we pass the substitute LC 292423S.
Ms. Ballinger moves due pass of House Bill 71 by substitute LC 296423S, second by Mr. Setzler. Are there any amendments? Ms. Ballinger offers the amendments as outlined by Legislative Counsel earlier, which I think we all got. Any question about that from the members? Seeing none, is there any objection to the technical amendments offered by Ms. Trapp? Really, they're not technical. They were not technical, but they were conforming. Thank you. Thank you. Any objection to the conforming amendments offered by Legislative Counsel? Hearing none, they're adopted. Are there any other amendments? Hearing none on the general. Mr. Setzler.
I would like to offer an amendment. I don't know that we've got. I think it's. I would ask counsel to advise to the contrary. I think what I'm trying to accomplish would be striking line 65 in its entirety and renumbering. Where the indication of the board's vote, the tally of the board's vote, purely under the circumstances of commutation of a death sentence, if that's stricken, I believe it accomplishes the policy objective discussed earlier, Mr. Chair.
Let me ask the author for. Yeah, let me ask the author for his opinion on his position on that proposed amendment.
Well, Mr. Chairman, I'd hate to use the word compromise, but again, my personal belief on this issue is that it should be total transparency in this, and that each member should be able to have their vote tallied individually, but in working with the Pardon and Parole Board in an open, honest dialogue. And again, I want to say publicly that the board has done an outstanding job working with me, the author, and with prosecuting attorneys counsel and victims groups, and they didn't create this system that they operate under. It's been created, for many, many years, and I believe that they too see that it's time to move this process forward. And I want to publicly thank them and the chairman specifically for his work, and Michael Nell, the director. But we came to this agreement that the board felt like they could live with this language. It was less than what I would have liked to have seen initially, but after conversations with prosecuting attorneys counsel and with others, I stand by the language as it's submitted in the substitute, Mr. Chairman.
Okay. Mr. Setzler offers the amendment to strike line 65.
Mr. Chairman, could I indulge the chair? I don't know if we've got all of our members here. Are they going to step back in a sec? I presume we have a quorum.
We do.
Do we have all our members that are?
We barely have a quorum.
I don't know if Mr. Pack just stepped up momentarily or otherwise.
I don't know, but we're here, and we have a quorum. So, would the gentleman like to pursue his amendment?
I would. I just wanted to see if it would indulge the chair to ensure that all the committee members that are in the 132 suite are present to vote.
I keep track of a lot of people, both here and at home. So, if a member is interested in participating in a vote, they'll be in this room. No, we had a quorum. So Mr. Setzler missed you. Mr. Pack, let me tell you where we are. Let me tell you where we are, Mr. Pack. Where Mr. Setzler is offering an amendment to strike line 65 that would delete the requirement for the board vote, the number on a death commutation of a death sentence. Of course, the individual member votes would not be that's already not included, but this would, and what we do include currently in the substitute, the number of the vote, 4132, whatever it may be. Mr. Setzler's amendment is to strike line 65 so that the actual vote number, the tally, as it were, would not be included. Mr. Tanner has responded that we have a fairly delicate compromise with the board that that was, I wouldn't say hard fought, but was certainly vigorously discussed, and that his position as the author was that he'd like to leave the compromise as is. That's where we are. All in favor of Mr. Setzler's amendment signify by saying aye.
Aye.
Opposed? No. Let me get a hand vote. All in favor, please raise your hand. 1, 2, 3. Opposed? 1, 2, 3, 4. And the amendment fails. Are there any further amendments? Seeing none, all in favor of the gentlelady's motion of due pass by substitute of LC 296423S signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Tanner.
Thank you, Mr. Chairman.
Thank you, members of the committee. We're adjourned.